Hello, everybody. Welcome to the Art of Estate Planning Facebook Live. It is the 14th of July, 2022. And today I am joined by two special guests. We've got Daniel Taborsky and Lisa Monaco from Birchstone Tax Law. Welcome.
Thanks,
Thank
Tara.
So it's actually, this is your second time coming back on the program. And I'm firstly, really grateful because we had a last minute cancellation and you were able to jump in and change the topic for me. So on behalf of everybody, thank you so much, especially in this busy time of year. And just so everybody knows, this is the second time getting Dan and Lisa back. Last presentation they did for us was in September 2020 on Division 7A and estate planning. So Dan and Lisa are pretty much your people when it comes to estate planning and tax law. And today, the topic we're talking about is around family trust. So we've got Section 100A, that is the technical title, but basically what we're talking about is the ATO's recent change to their interpretation of some of the rules relating to family trusts. And I know I was saying to Dan and Lisa, we probably are going to have a bit of a diverse mix of experience levels around this topic because obviously the accountants who are watching you will have been across this. It's been the headline in a lot of the tax updates in the last few months. And if you're an estate planning lawyer or a litigator or someone in family law, you might go, I've never heard of this at all. So we're going to try to bridge the gap and either and start off quite broad, but then we can get down into the nitty gritty as well because Dan and Lisa are experts on this topic. But the easiest way for us to do that is if you can be interactive and share in the comments, any questions that you have to try to guide us on getting the right level of detail for you. So if you're not a tax person, we're not trying to teach you about how to give legal advice or tax advice on this topic. What we're trying to do is really just get this on your radar so that you're broadly aware of it. If you see transactions happening or changes happening in a family structure involving trusts and you're sort of unsure why it might be done, then hopefully today's session will give you some context for that. And then also if you are in if you are a tax advisor, then now's your chance to drill Dan and Lisa because they'll be able to go deep into that technical content as well. So we can see the comments. And yeah, thank you. I can also see someone has already tagged someone saying, come and listen to this presentation. So thank you for that. Share it with your friends. What I might do is hand over to Dan and Lisa to get started.
Thanks, Tara. Section 100A has been a really big topic of conversation and debate, particularly this year in our tax and accounting circles. So there's a couple of things we are going to run through today. If we just flick over to the agenda. So we'll run through Section 100A, a refresher, so what it is, where it's going to apply. We'll look at the ATO's further guidance, and that's what's caused all the conversation and debate earlier this year. A bit around trust distributions generally. Given that we're through 30 June, we'll focus on action points for post 30 June and possibly what to do around historically the distributions that might need to be de-risked in that sense. So those are the kinds of topics we have in mind for today. I will make Dan do the heavy lifting as I often do. So I'll hand over to Dan to talk us through the tax side of Section 100A.
All right, thanks, Lisa. Okay, I'm going to try and give a bit of an overview of Section 100A. I've spent most of my time talking to accountants about this. So Tara, please pull me up if I sort of assume stuff that I shouldn't be assuming. I think the first thing to probably note is that there has been no change of the law. So the law has actually not changed. Section 100A is a provision that was introduced, I think about 43 years ago. So we're not talking about anything that's changed in the law very recently at all. What's changed is the ATO's approach to how they're going to administer Section 100A. And that was kind of marked with the release of a number of different guidance materials back in February this year. So that was promised. This guidance material was promised for a long period of time, and we eventually saw it in February. I'm not going to go into detail in the guidance materials, nor am I going to go into detail on the different cases that have discussed Section 100A to date, and there's only been a handful of those cases, most of them dealing with quite blatant tax avoidance schemes. But what I will spend some time doing is sort of refreshing on the basics of Section 100A, so we can try and get everyone on the same page when we come to talk about some of the practical aspects. And as Tara said, please fire through questions in the chat if you have any comments or we've sort of assumed things that don't make sense to you. So the first thing, just a general comment on Section 100A, it's an anti-avoidance provision that deals specifically with trust distributions. So in the tax law, we have Part 4A, which is a general anti-avoidance provision that can apply to potentially any transaction. Section 100A is also an anti-avoidance provision, but it applies specifically where trust distributions from for example, family trust are involved. And what it's really trying to capture is the situation where a distribution goes to one beneficiary. So the trustee resolves at the end of the income year to distribute income to that beneficiary, but then the income doesn't actually go to that beneficiary. Instead, the benefit of it goes to someone else. And it's really that mismatch between the beneficiary that receives a distribution and under the taxation of trusts, they're the ones that pay the tax on that income, yet the benefit of that distribution goes to someone else. And so I've got a little example here to kind of illustrate this. So for Section 100A to apply, the very first thing you need is you need a trust. So we've got our family trust here. There then needs to be a distribution of income to a beneficiary. So that's what we call a present entitlement is created. And if that present entitlement isn't satisfied by the trustee generally paying the cash of the distribution to the beneficiary, it becomes what we call an unpaid present entitlement. And so the situations where Section 100A could apply is where the benefit of that distribution doesn't immediately go to that the beneficiary who was made presently entitled. Instead, the example here is there's been money that's been either paid or lent to another beneficiary, and the reason the ATIS would concern the ATO is because in this case, Bruce might be an adult child and may well be below the tax-free threshold. And so, say he was distributed $20,000, he may have paid effectively no tax on that income. Whereas Julia, maybe his mum, is a high-income earner. Her marginal tax rate is 47%. So if that $20,000 went to Julia instead of to Bruce, there would have been $10,000, roughly 47%, $10,000 tax payable on that. And so here, Julia, in this case, has essentially got used to the funds essentially tax-free because the distribution has been made to the adult child, no tax has been paid, and yet that she still gets the economic benefit of that distribution via loan or payment from the trust. That's a very common situation where 100A could apply, but it can also apply in situations where Bruce is, for example, made presently entitled to the income, but he doesn't call on the income, and the funds remain in the trust. So the fact the funds remain in the trust and aren't paid to Bruce relatively quickly after he's been made presently entitled, that itself can give rise to Section 100A, because you now have Bruce being made presently entitled, yet someone else, in this case being the trustee, benefiting from the funds representing that entitlement.
And Dan, just to jump in and ask a question, I mean, this happens because there's a disconnect between like what needs to happen at the end of the financial year and in practice, right? Like all year long, people just spend the money or use the money from their family trusts how they like. And then at the end of financial year, the accountants are like, okay, we need to do our distribution resolution and allocate it out. But that process about allocating the benefit for tax purposes is often quite disconnected from the reality, isn't it?
Correct. Yeah. So the trust, like assume the trust has a bank account. The parents might be using that bank account for their day-to-day living, and they're just spending money as they go during the year. And so they're racking up a loan in the accounts of the trust. But when it comes to the end of the year, the way the trusts themselves aren't taxed. They're not taxable entities by themselves, and the trustee won't generally pay tax. The way tax for a trust works is it works on which beneficiaries the trustee makes presently entitled to the income at the end of the income year. And that need not match up with the beneficiaries that have actually received the income during or after the year. So there can be a mismatch between who's made presently entitled and who's received the income. And it's where that mismatch occurs is where 100A can really apply.
Yeah, that makes sense.
Okay, we've got a question, but I think I'm just about to deal with that. So we might flick over to the next slide unless you have any more questions, Tara.
Yeah.
Okay. So I'm going to go through the law, but I've kind of put in a diagram. So hopefully this makes it less scary than actually looking at the actual words of the legislation. But I think this is really a good way to sort of dispel some of the myths around Section 100A. So the first sort of requirement, and you think of these as also tick boxes we need to tick for Section 100A to apply. So the first is there needs to be a beneficiary who is not under a legal disability that is presently entitled to a share of income of the trust estate. So generally this would be pretty straightforward, but maybe Lisa, do you want to touch on some issues where that present entitlement might not be properly created?
I knew you weren't going to let me get away with doing no work. Yeah, so there are some issues that we've come across, and they usually include situations where maybe the beneficiaries weren't validly added as beneficiaries of the trust, but distributions were still made to them, or situations where the resolution wasn't signed by a person who needed to provide consent to a distribution. And the other thing we've seen is that the resolution might have been made without considering the definition of income in the trust deed. And so that sort of led to an outcome that the trustee really didn't have in mind. So I guess with that in mind, the kinds of things that need to be front and centre when preparing a distribution resolution would be confirming if the intended beneficiaries are actually beneficiaries of the trust. And that sort of goes beyond just looking at the definition of beneficiary. It also means you have to look at if they're an excluded beneficiary, or if they were subsequently added, whether that was done validly. So there's a little bit to that. Also, as I mentioned, looking at the definition of income really closely. If the definition allows the trustee to determine income and the trustee intends to use that discretion, then the resolution should be made reflecting that determination, sorry. So also double checking that which trustee powers are being exercised and if consent is required. Some trust deeds only require consent for the first distribution, and then after that consent isn't required. So there are some nuances to it as well. And importantly, making sure that the resolution is signed by everyone who needs to sign it. So if someone needs to give consent, that their signature's on it. But also if the trustee and the guardian are the same person, that there are separate signature blocks where that person signs in both capacities. So that would be best practice in those circumstances. A lot of these really just come down to reading the deed in a lot of detail and ensuring that the terms of the deed are being complied with.
Thanks, Lisa. So I think the takeaway there is there's a whole bunch of formalities that need to be complied with for a distribution from a trust to actually be valid. And if we don't comply with those distributions, those formalities, then potentially we have bigger problems in Section 100A. We might not have a valid distribution at all, and we don't even get to Section 100A. We can have like default beneficiaries being taxed. So if the trustee doesn't make a resolution on how it wants to distribute income by the end of the year, then most trustees will provide what happens in default of a valid distribution. Or if there isn't default clauses, then it could be the trustee that's taxed, and the trustee is generally taxed at the top marginal tax rate. So it's generally something you want to avoid happening. Now, just going back to the words of that sort of first step, just focusing on some other aspects. There's questions come through around testamentary trust, and then is there a definition of legal disability? So the first question around testamentary trust, yes, Section 100A can apply to testamentary trusts in the same way it applies to all other trusts, but there's that requirement there that it can't be the beneficiary who's received the distribution or is made presently entitled is not under a legal disability. So very relevantly, minors, so people under 18, they are considered to have a legal disability. So Section 100A cannot apply, will not apply to distributions to minors under a testamentary trust. So that, I think, is super relevant for this group.
You almost gave me a heart attack, Dan.
Did I? Sorry, I sort of tricked you going into that. Yes, minors under, but just to be super clear, minors under testamentary trust, Section 100A cannot apply.
So, okay, so the headline is once the testamentary trust is established, all the normal taxation of trust rules apply to the testamentary trust, but we have that accepted trust income exception that applies specifically for testamentary trust, and really that's relevant for distributions to minors. So that's how, if it's not undermining the accepted trust income benefits of the testamentary trust, but if you do go and do things with adult beneficiaries that Section 100A can apply to, then you're in that realm. Is that right?
That's right, yeah. So adult kids, it's the same under an ordinary family trust as it is under a testamentary trust. Yeah. So the same risk for Section 100A can apply under both.
So I think this is Joseph's question. So Joseph is an accountant, I'm pretty sure. I hope I got that right, Joseph. So your question about 100A and accepted trust income, hopefully we've answered that to say that it's not going to undermine the benefits.
Okay. Good. Okay.
We've got one more, Dan.
One more? Yeah. Which one do you want to go? Do you want to read out the question, Tara?
Yeah. So is there a definition of legal disability? And this is from Stephen. Thank you.
Yeah. So I think yes, there is, and I think the main aspect of that is that's relevant, particularly here, is that minors, people under 18, are under a legal disability, so they are carved out from the application of Section 100A. Yeah. The other relevant point here, now we're probably getting a bit more technical, is it has to be a present entitlement to a share of income of the trust estate. So a trust can distribute either income or capital, and if it's a distribution of capital, then again Section 100A can't apply. And where this can become relevant in practice is if we have a capital gain. A capital gain we could define, and it depends on how income is defined under the trust deed, because what is income from one trust may vary from what is income in another trust, depending on how the trust defines it. But assuming your trust defines income to be sort of ordinary income for trust law purposes, or there's a discretion in what is and what isn't included within income, you can define income to exclude capital gains. And then we can potentially stream capital gains through making distribution of capital and have the tax flow the correct way to the right beneficiaries without having a risk of Section 100A applying. So that's potentially relevant where we have capital gains. Okay, I might keep going through the steps, Tara. So if you say no to that, so you don't have a beneficiary who's over the age of 18 that's presently entitled to income, you don't have that, then 100A can't apply. But assuming you do have that, you have got a beneficiary over 18 presently entitled to income, then Section 100A may apply if all the other requirements are satisfied. The next is that there needs to be an agreement, arrangement, or understanding. Now, that's a very broad definition. For those tax people in the room, very similar to the definition of scheme for Part 4A, but with one significant difference. An agreement the Section 100A, it needs to involve two parties. Two people need to be involved. So if you have a situation where the trustee is running rogue and just doing things of their own volition, you might not meet the criteria for 100A to apply. One thing the cases do say that the two people, generally one of them will be the trustee, but the other need not be the beneficiary. It can, for example, be the trustee's advisor, so their accountant could be the second person. So yeah, that's that requirement. There needs to be an agreement between two people. Again, if you haven't got that, Section 100A can apply, but if you do, then Section 100A potentially can. Someone else, so the agreement needs to provide for a payment or transfer of property to another person other than the beneficiary. So as we saw in the example before, that could be a payment or a loan to another person, can be the funds being retained by the trustee. But if the beneficiary is presently entitled to $20,000 worth of income and they're paid $20,000 of income and they retain that money, then Section 100A can't apply because there's no mismatch between who's been made presently entitled to the income and has paid tax on it, as opposed to the person who's actually received the benefit of those funds. Okay, so there, yep, again, first three requirements. The fourth one is this is an exception, and this is where most of the controversy sort of comes down to. The question here is, this is an exception from 100A. If the arrangement is entered into in the course of ordinary family or commercial dealings, then that is an out from 100A. Section 100A can't apply if the arrangement was entered into in the course of ordinary family or commercial dealings. Now, the million-dollar question is, well, what exactly does that mean? And the answer is, well, no one really knows what it means. The ATO has one view on what it means, which is, I would say, a very narrow view. But most of the tax profession have a much broader view on what the exclusion means. A simple way of contrasting the two views is the ATO's view is that if, I'll summarize it as this, the ATO's view is if the tax purpose of making the distribution is too dominant, then the dealing can't be ordinary, whereas the profession would, and I probably fall within this camp, would say that tax purpose and the ordinary family dealing exception are separate requirements. And so when you're looking at tax purpose, which is step 5, below, the next step 5, you look at tax purpose. But the ordinary family dealing exception is entirely different, and you don't consider tax purpose when you're looking at that. They're separate requirements. So to give you an example, the ATO would accept that sort of an interest-free loan from a beneficiary, from, say, a parent to a child, that could be an ordinary family dealing. But that's premised on the basis that the beneficiary that's made presently entitled, so the parent, is on a high tax rate, whereas the beneficiary that receives, or the person that receives a loan, the child, is on a low tax rate. So you have a loan going from a high tax rate beneficiary to a low tax rate beneficiary. If the reverse happens, so you had a distribution to the child who's on potentially low or below the tax-free threshold, and they choose to make a loan to the parent who's on a higher tax rate, the ATO may well argue that, well, that's not ordinary in this case because the reason for the distributing to the beneficiary is predominantly driven by tax purposes, and that means you can't have an ordinary family dealing. Whereas the opposing argument is that, well, if you consider that interest-free loans between family members are ordinary, which I would say quite arguably is, family members do generally, if they do lend to each other, it generally is on interest-free terms. It's not on commercial rates of interest. Then it doesn't matter if it's coming from a high-rate beneficiary to a low-rate beneficiary. What's important is that interest-free loans between beneficiaries are what is ordinary, and that should fall within the definition of an ordinary family dealing. But really, this is kind of the million-dollar question in what that actually means, and there really is limited guidance on what that phrase means. And this is where most of the matters around Section 100A, whether it applies or not, depends on the definition of ordinary family or commercial dealing, and hence why there's a large amount of uncertainty around when this section will apply. Tara, any questions at this stage, or should I just finish running through these steps and then we can go into questions?
Thanks, Daniel. We've just had one more asking if there's a specific section in the tax legislation that defines legal disability. So that could be putting you right on the spot. But yeah, I guess the question is it defined in the legislation, or is it more of a common law concept?
I think it's a common law concept, Tara. I don't think there's actually a section that defines it. I'm not 100% sure, but I'm pretty sure.
I've just checked. Sorry, it's not a defined term in the Tax Act.
No. So we're relying on common law concepts.
So yeah, I guess so, because that does include like someone who doesn't have capacity to make decisions for themselves or has a disability. So I guess it's going back to those first principles.
Yeah.
Yep, that's all the questions for now. The rest is just hecklers for me.
Okay, right. Okay, so we got this nebulous concept: is an ordinary family dealing? If what has happened is an ordinary family dealing or an ordinary commercial dealing, then we are out of Section 100A. It can't apply. But assuming it's not, or we can't convince the ATO that it is, then the other two requirements is that there has to be an agreement, or the agreement has to be entered into for the purpose of reducing a person's tax payable. Now, it's quite a low test. It's a subjective test, and it's just a purpose. So there may be other purposes of making the distribution, but if just one of the purposes was to reduce tax, and it need not be the sole or dominant purpose, like for Part 4A, just needs to be any purpose, then that's not a get out of jail free card for 100A. A purpose will mean 100A will apply. In reality, I think we have to accept that when we sit down and do trust distributions at the end of the year, generally people are thinking about tax when they're doing them, and they will try and distribute between family members in a way that creates the lowest tax rate within the family. And so I don't actually think this is a way we get out of Section 100A. I think in most cases it'll be difficult to show that it wasn't a purpose of reducing tax. And then the final requirement is that there has to be some sort of nexus between the beneficiary being made presently entitled to the income and the agreement itself and what would happen to the funds after the beneficiary receives it. And so this generally requires something to be done, or some discussions to be had before 30 June, before the distribution is made. And so if nothing happens before 30 June, there's no discussions with the beneficiary, arguably there is no agreement at that stage, and therefore you can't say that the beneficiary's entitlement arose out of an agreement which didn't exist at that stage. So that's going to depend on the facts, and the ATO would say, well, if you've got the same pattern of distributing to beneficiaries every year, you distribute to the adult child every year, and the child doesn't call on it, then the ATO would say, well, that pattern of distribution and pattern of not calling on it creates kind of an implied agreement between the beneficiary and the trustee. But if it's a one-off thing, it's probably a more difficult thing for the ATO to argue. So they're kind of the requirements that you need to be met for Section 100A to apply. I guess what then happens, I mean, we've spoken about 100A and what it does and when it can apply, but what does it actually mean if it does apply? Then the effect of 100A is that the beneficiary who's normally taxed on the income, so as we said, trusts don't pay tax. Instead, the trustee distributes his income at the end of the year, and the beneficiaries who receive that distribution, which may just be a paper distribution, not actually a physical payment of cash, they're the ones that pay tax on the distribution on the income. If Section 100A applies, the beneficiary doesn't pay tax. So that distribution is essentially ignored for tax purposes. And instead, the trustee pays tax, but the trustee pays tax at the top marginal tax rate. So that's a punitive provision, which is if you were distributing to an adult child who might have been below the tax-free threshold, you're going from something that was essentially tax-free to something that's now going to be taxed at 45%, 47%. The other really scary thing about Section 100A is, unlike most provisions in the Tax Act, the ATO has a limited period of time where they can make amendments. So generally 2 or 4 years after the tax return was lodged. Not so with Section 100A. 100A has an unlimited period of amendment. So the ATO can go back to 1979 when the section was first introduced and do assessments back to then for stuff that happened multiple years ago. And that's what makes it particularly scary in the context of ATO audits. So I've got just one example I've been involved with, and I've heard of many that have gone back far further, but this is going back to 10 years ago to 2012 was when the first distribution was made. So yeah, potentially clients may have significant exposures to Section 100A depending on the view the ATO eventually comes to on how it's going to apply these provisions. The final point I'll just note about 100A, so it essentially disregards the distribution for tax purposes and results in the trustee being taxed. But for every other purpose, that beneficiary is still entitled to the funds. So it doesn't. So you may have distributed to the adult kids. The trustee may get taxed on it because Section 100A applies, but that doesn't mean that the adult kids still aren't entitled to the funds. That distribution still exists for the purposes of trust law, and they can still call on those funds at any time. So really, is that disconnect between tax and the law, the other law. All right. Should I keep going, Tara?
Yeah, and I've got the cogs turning very slowly in my brain. So can I just go back to your point about that there is no cutoff in terms of how far back they can audit this, because all of the like practical compliance guidance and everything came out just this year, but they're treating this differently to a change in the law, and that they're saying this has always been the law and you people have just been applying it incorrectly. Is that what they're saying? So there's no like grandfathering indemnity or like, safe haven time period?
Yeah, so essentially that's right. So the ATO, one of the guidance materials it released was a practical compliance guideline, and that kind of has its framework around risk and when it'll look to sort of review taxpayers. So and it separates arrangements into different zones. So they've used the date of 1 July 14 as a sort of a red line kind of date, and they say sort of arrangements before then we generally won't be looking at, albeit with some caveats that I'll come to. But anything post 1 July 14 is kind of fair game. And the reason they choose 1 July 14 is that's when they first published on their website a fact sheet expressing their sort of, views on Section 100A potentially having a broader application to what they had applied it in the past. And they say from 1 July 14, taxpayers have been on notice of the ATO's views on Section 100A. But you have to note that fact sheet is very limited in guidance compared to the guidance that has come out this year. And so that, I think, is definitely been a bone of contention around the profession and the tax office around whether this guidance is going to apply retrospectively, even if only back to 1 July 14. I think the profession would say, okay, you've got these views, that's fine, you're entitled to have your views, but let's just apply it from going forward. Let's not go back to 1 July 14. Let's just apply your views essentially from this year going forward. The 1 July 14 one is also caveated as well. As I said, that audit matter I had goes back to 2012. So if the taxpayers have lodged their returns late, the 1 July 14 sort of safe harbour is off the table. As if there's an arrangement that's been happening from before 1 July 14 and continues post 1 July 14, and they look at the stuff that's happened after 1 July 14, but they're going to go back and review the prior years, and they're not going to stop at 1 July 14. They're going to keep going back to as far as when the arrangement first started. So if you've been distributing to adult kids since the 1980s and that's happened through to today, then if the ATO reviews and they think there's a 100A risk, they're going all the way back to the 1980s, not until 1 July 14 and stopping there.
You really have to feel for taxpayers, don't you? This is just like it's taken them 8 years to come out with more formal guidance once it's been put on the radar.
It is. It's been an extraordinary long time for the ATO to publish guidance on this.
Yeah.
And it's quite. I mean, it's quite interesting the timing that it's come out. There was as I said, there's not been many cases that have dealt with 100A, and probably the other thing to note as well is 100A was introduced really to deal with what was a type of arrangement that was called trust stripping, and so we're talking like really blatant schemes where you might there's sort of like there might be like an entity that has losses completely unrelated to the trust, and they might be both clients of the same accounting firm, and the accounting firm connects the trust client that's very profitable with a loss entity from another client and says, hey, why don't you, profitable trust, distribute some funds to the loss entity, use up its losses, and there's probably some fee that goes across for that, but essentially the benefit of that distribution doesn't go to the loss entity, it remains with the controllers of the trust. And so it was meant to deal with like really blatant tax schemes, which are so far away from what the ATO is now seeking to apply to Section 2. Distributions to adult kids was not at all in the minds of the people when they were drafting this section. And look, that doesn't mean the section can't apply to it, but I think that has to be kept in mind when you're interpreting phrases like ordinary family or commercial dealing. This was a section meant to deal with the most egregious of taxpayer behaviours, hence the reason it's got an unlimited amendment period. Not even Part 4A, the general amendment period, has an unlimited amendment period. It's got the standard 4-year amendment period. But 100A, the conduct it was considered to deal with was considered to be so egregious that it's inappropriate to have an unlimited amendment period. And there's really been, the cases that have been on 100A have all been dealt with that really egregious side. So there's been 4 cases up until last year. There was another case that came out just before Christmas last year. And if you've heard of the Guardian AIT case, that is the case. And that was, I mean, the facts are not super relevant to adult distributions to adult children, but it wasn't like a super tax-driven scheme, a really an egregious scheme like the original cases were that dealt with Part 4, Section 100A. And I won't go through the facts, but it's relevant to know the ATO actually lost on that case and lost in all 3 different elements of the case. So the court said, well, 1, there was no agreement in place when the present entitlement was created. 2, it was an ordinary family dealing. And 3, there was no tax purpose. So they lost on 3 different elements. And then yet they still come out with this sort of guidance which completely upholds their view of what an ordinary family or commercial dealing is. So the timing of I found the timing of the release of the guidance quite interesting. After they've been holding off for so long, they release it after there's a case where they've just got completely smashed.
I mean, I think there is one thing clear, is that the ATO is just persistently chipping away at the tax flexibility of discretionary trusts and even testamentary trusts. You know, we sort of saw that when they started changing the rules around Division 7A and using corporate beneficiaries. We've seen that where they have changed the integrity measures relating to accepted trustee income for testamentary trusts. And this just seems like that long reach of them just trying to limit the tax benefits of discretionary trusts. And I have to say, you know, historically, family trusts have just, taxpayers kind of have had a bit of a laugh in terms of taking advantage of the difference between what happens from a tax perspective in terms of allocating the funds versus what's happening in reality. So I really think that they're just trying to align that so that the funds flow with the tax treatment, really.
Yeah, and but why don't we? I've got a couple more slides, Tara. They sort of. I'm not going to go through the ATO guidance in detail, but they did just before 30 June release some more summarised. Sort of, there wasn't really much new in it, but just a summarised version of their guidance. So if we just sort of the ATO's the practical compliance guidelines splits sort of arrangements into 4 different zones: green, blue, green low risk, blue medium risk, red high risk, and then white sort of is that pre-1 July 14 stuff where you're kind of in a safe harbor zone if you fall within all the other criteria that need to be met. But just to sort of highlight some of the situations where the ATO will say an arrangement is low risk is where the benefit, I guess, when a beneficiary receives their entitlement themselves and they benefit from themselves, or if they receive it or their spouse or dependents benefit from it. So beneficiary itself benefit from it, their spouse is okay, and their dependents. But if you flip that and it's an adult child that receives it and they give the benefit to their parents, that's not okay, according to the ATO. And then there's another example in the practical compliance guideline that it's relatively narrow, but it will apply, if not exactly on these terms, on very similar terms to a lot of taxpayers. So this is where the trust it makes beneficiaries presently entitled because it doesn't want the trustee to be taxed at the top marginal tax rate, but the funds are still required for use in the trust business, or the trust wants to reinvest those funds in other income generating assets. And so the ATO says in most cases where the beneficiary's entitlement is retained by the trustee for use in sort of the business or income earning operations of the trust, then that'll be low risk. And then they have these caveats. Well, provided that either the beneficiary is employed in the management of the business, so if they're involved in the management of the business making the high-end decisions, then that'll be okay. Or the beneficiary or their spouse either is or controls the trustee, or if the beneficiary we're talking about is not an adult child, but it's a company, so you're distributing to a bucket company, then if that distribution is put on a complying loan agreement that complies with the terms of Div 7A, then those situations will be considered low risk. Contrast that with these examples. So these are examples the ATO gives that are high risk. So the example here is a university student who has no other sources of income, is made presently entitled to 180K, so it brings them up to the top marginal tax rate. And then that student then agrees to pay that 180 less the tax that's payable on that distribution to their parents for the costs incurred by the parents when incurred when the student was a minor. So the ATO refers to it as property parental expenses, and it will say that when an adult child is reimbursing a parent for those expenses that the parent incurred while the child was a minor, so for example, their private school fees, that is not okay. That breaches 600A, and they would consider that's a high risk arrangement that falls within their red zone. The other example, well, there's more than two examples, but another example they highlight is this, what they it's sort of colloquially referred to as a washing machine arrangement, where trust distributes to a company, company then pays a dividend to the trust then distributes back to the company, and it keeps going around in a circle between the trust and the company. That the ATO would consider 600A also applies to that arrangement. Now, so that's what the ATO says. We've kind of put together this sort of slide that I kind of like. This is not law. This is just sort of our sort of interpretation to try and help this make sense to people. We've put together like a risk spectrum, particularly dealing with adult children, and looking at like what activities are going to result in higher risk and what are going to result in lower risk. So if the trustee makes the adult child presently entitled to income, and that amount's actually paid to the child, and the child holds onto those funds, then very low risk. Like Section 100A can't essentially apply. And I just emphasize the child holds onto it, because if some people, one of the myths is if you pay the money to the child, then 100A can't apply. But if the money is paid from the trustee to the child, and the child then gives it to a parent, then 100A is going to look through that, and 100A can still apply to that type of arrangement. So moving up a little bit higher in the risk spectrum is if the child's made presently entitled, it doesn't call on the funds, but instead those funds are retained within the trust. So the trustee uses it either for their own business or for other income generating activities. And as we saw, there's the ATO accepts if you fall within those criteria around sort of the involvement of the beneficiary in the trust, business or in the sort of control of the trustee, that would fall within the green zone, and they'd accept that's low risk. I would say even if you don't fall within those criteria the ATO has set, so the child isn't involved in the business of the trust, I still consider that's pretty low risk on a Section 100A risk. Moving up in the risk spectrum, well, what if instead of the funds being called on, they're actually lent to another beneficiary? Then that, I think, jumps up in the risk spectrum, and I've been involved in a review where that's happened. They've lent funds to relatives, and the ATO is considered Section 100A applies in that situation. And then I think if the child ever gifts the funds back to the trust, so they say, look, thanks for the distribution, but I don't want it, or they gift it to another beneficiary, then I think that's that jumps up higher in the risk spectrum. And that's probably, the ATO is probably going to be most interested when it's either gifted to parents or, back to the trust. So that's sort of I think that's kind of a good framework to kind of think about adult distributions to adult children, and what situations are likely to be low risk and which are likely to be high risk. Now, have we got any questions, Tara? Otherwise, I think Lisa might have some sort of Dorothy Dix's lined up to sort of go through.
Someone has just asked if we can go back a slide with the examples in the red zone. They might have a follow-up question to that. I have some questions about what this might mean or what impact like estate planning practitioners might see, or like are people taking steps to try to tidy this up, or has that ship sailed?
Well, from a technical perspective, I mean, the 100A risk was sort of, it was there when you made the distribution, and that's like really the facts when you made the distribution to the beneficiary, that's when Section 100A should be technically considered. In saying that, I think from a detection perspective and from like an audit risk, what happens subsequently can impact on the risk. So if that beneficiary is just sat within the trust for a number of years, and that's subsequently it's eventually paid to the beneficiary, then like sometime down the future, then I think the ATO is going to have less concern with it than if it never gets paid to the beneficiary. Now, in saying that, as part of cleaning up an estate plan, you may want to, I say, Tara, I'm thinking you may want to forgive UPEs for certain purposes. Is that kind of where you're heading, Tara?
Yeah, or I was just wondering, like, is it likely that we will see less UPEs from family trusts to adult children moving forward as a result of this?
I think 30 June this year, I think most tax agents and accountants were probably discussing with their clients like this guidance and saying, look, this is the ATO's view. It's still in draft, and it's only the ATO's view. The law might be different, but what do you want to do this year? Seeing as it's clearly on the ATO's radar. And I think you would have seen this year that at least these types of arrangements, like in that red zone, I think most of them would have stopped this year. I think people they'd be pretty brazen if they keep doing red zone arrangements. Not saying they're not, like the ATO could be wrong on it, but I think from a risk detection perspective, I think those types of arrangements sort of been reduced, and I don't think many of those were entered into in 30 June this year or last year. For other type of arrangements, I think people would depend on the risk spectrum of the client, because yes, we can just stop distributing adult kids at all, but we have to realize when we're doing that, yes, we're minimizing or potentially eliminating our risk that Section 100A could apply, but potentially we're paying more tax than we otherwise might need to under the law. And so we're taking an overly conservative position. And so it probably depend on the sort of, the risk spectrum for the client. Do we want the extra comfort to know that, well, this is not going to be an issue in the future and we'll pay a bit more tax, as opposed to, it's just a draft view from the ATO. The ATO might be viewed wrong. We're just going to continue what we've been doing in the past, and we'll reassess once we have a final ATO view and there's some more guidance from the court. And there is guidance from the courts coming. There are the Guardian cases on appeal, and there's some other cases going through the system at the moment. So there will be more guidance from the courts in the next, definitely by 30 June next year and over the next few years, we're going to see more guidance, I think, on this.
Okay, all right. So I hadn't quite realised that they hadn't issued the finalised
No, draft guidance
yet.
before 30 June. They do expect to finalise it sometime, I think, before end of the calendar year. But at the moment, it's in draft, and it really doesn't really apply until 1 July this year.
I mean, they waited 8 years to update their website last time. Who knows how long we'll be waiting?
Exactly, that's true.
Okay,
Very true.
It's a watch this space. It's a have it on your radar. If you're an estate planning lawyer and a client's seen something about this and they're stressed about testamentary trusts, you can rest assured that it's not going to undermine the income tax to minor benefit. But once those beneficiaries are adults, then it's open slather, the same rules as family trusts apply.
Yeah.
Okay.
Sorry, maybe just before we wrap up, I might just touch on, because often question is, well, is there anything practical we can do to minimise our risk here? Like, what can clients be doing to sort of protect themselves? And I think something that's really helpful, because based on our experience with ATO reviews, they really, the ATO really doesn't like when the beneficiary doesn't know about the distribution. And so I would think some very basic sort of housekeeping and documentation you could have in place. And I think as a tax profession, accountants got very good at doing their distributions before 30 June. But what happens after 30 June, not much happens. So I think something that could happen now after 30 June, after the trustees made a distribution, trustees should think about sort of being writing to beneficiaries, advising them in writing of their trust distribution. Hey, beneficiary, the trustees distributed $100,000 of income to you. Getting the beneficiary to acknowledge that, I understand what that means. I know that I can call on that money at any stage, but I'm not going to do that at this stage. In fact, I'm going to authorize you to use that money as for a particular purpose or as you see fit. So really, we've actually, I think you can put this together yourself, but we've put together a very simple sort of letter from the trustee to advise beneficiaries of their entitlement, and then a form for the beneficiary to complete to say, hey, I'm aware of it. I know I can call it at any stage, but I'm instructing you or giving you authorization to use these funds in this particular way. And I think having some documentation like that in place will be something really helpful in the event of an ATO review. It's not going to mean the ATO 100% guarantee the ATO won't be concerned, but you'll be in a much better position than someone who hasn't got that and can't prove the beneficiary even knew about the distribution. And then, so that's for the current stuff. And you can do something similar for the prior stuff as well, the historical stuff. Again, it's always better if documentation is done contemporaneously when the sort of distribution was made, but better late than never. If you have the trustee write to beneficiaries now saying, hey, ATO's just issued this guidance around Section 100A. We thought it's prudent to write to you to just point that out to you and to just remind you that you have this entitlement for X dollars, which is built up over the number of years. Let us, can you please confirm that you have been aware of this, that you've decided up until now not to call on this entitlement, and that you still continue to allow the trustee to continue to use those funds as you like, or as a trustee sees fit. So I think that some really basic documentation, I think, will go a long way of minimising the risk for your client and being able to support your position if the ATO does in fact do a review.
And Dan and Lisa, am I right in saying that you've actually packaged those resources up in a pack that advisors can buy from you?
Yeah, we have. Yeah, so I think $99, and it's we've got it. We can give you a link afterwards, Tara. But yeah, you can essentially $99. It has those templates in there, and then you can just use it for as many of your clients as you want. So I think I think it's a great sort of offering, and I've got some really positive feedback on that.
Yeah. Great. Well, we'll put that link there if you send it to me, and I'll put it with this recording so people can access that. We do need to wrap up, but I just want to round out this question from Joseph, who is a financial advisor, not an accountant. So that was my mistake before. So, yeah, Dan or Lisa, do you want to just say the definitive word on minor beneficiaries of testamentary trusts?
Yep. Minor beneficiaries, Section 100A cannot apply to distributions to minor beneficiaries. So complete 100A, not something you have to worry about at all.
Yeah. So in terms of the strategy, using testamentary trusts to receive the life insurance from parents and distributing that to minor beneficiaries, Joseph, that doesn't get changed by any of this. That strategy is still quite tax effective in an estate planning context. So thank you for asking that. I might wrap it up because we're right on the hour. Dan and Lisa, thank you so much. That is a really complex topic, and you've done a great job at trying to sort of cut through all of the white noise and the complexity of the news articles to simplify it for us. So I'm really grateful for you doing that and for giving up your time today. So on behalf of everybody, a huge thank you.
Thanks, Tara. And if anyone has any questions, feel free to put them in the group, and Lisa or I will respond.
Keep an eye on it. Yeah.
So we're all we can all get tagged and see this in the group. So if you're watching the replay, keep asking your questions. We can all see it. And I will also post the link with the 100A documentation pack that Dan and Lisa have put together too, if you want to check that out. Thank you so much, everybody. Have a great day.
Thanks, everyone. Cheers.
Thanks.